shall acknowledge your issue, no firearms, keep a job, even though you can't go to it, and surrender the passport and don't leave the state. He's complied with all 9 of those. The only issue has been his wife reaching out and making this contact. You heard him on the phone. I know these are general orders, Your Honor, but this is not the case because of the specific facts. That's a very fragile lady right there, 32 years of marriage. You basically divorced them when they didn't want to, and I know the court did out of abundance of caution, and you do them in the normal case so that we don't have her at the war. But in this particular case, I believe even under 8.6, you could fashion a rule that if he so much as looks at her in the wrong eye, he gets picked up and goes immediately to jail. I just think you got to give her some relief. If you keep him in jail, it penalizes her and the family, Your Honor. This is not the kind of deal. If something was going to happen, again, there's 24 more days in there, excuse me. The third, 26 days. Connor saw him, and I played golf with him and his dad, known him forever, but Connor saw them on the third, nothing going on. 22 to 3 weeks after he told Bubba. I submit that you could modify the bond. You don't have to revoke. You can modify it. Put them on. They can only have contact certain hours. They can only do this or that. To give us some type of, they can solve the situation with the family, and he can stay in compliance with the order. Judge, he's tried to comply 9 out of the 10, and he even tells her, "I don't want to get in trouble," and it's freezing. But that's not a factor. But I mean, in all honesty, I understand why you normally put these in. Here you got an entire family. That's his wife, his daughters, his brother. They're all in support of this man. And it is going to be what it is, however the 12 decide. But, or it works out for it. But in purposes, the bond revocation here serves no purpose other than strictly penalty. And I think you can penalize it, but modify it, limit the contact. And you heard this young lady. She will certainly call whomever if he does something even sideways.
I take that as your closing statement.
I think I wrapped them up in one, Judge. The other thing is, I don't know if you've got this, but this is the letter that McCready sent to you. You probably didn't, because what happened was, I want you to take note of this. On, they had to pee on me. You know, when this thing first came up, it was in Flowood. So I called for a bond hearing. They said we'll do it Tuesday. Well, on Wednesday, the judge recused himself, sent it to you over at County Court. Okay, so I'll come over there. Come over and have the bond hearing. I get word that Kim's upset, wants the stuff. If her lawyer sends me a letter, I filed on October 17th a motion to modify bond. They indicted him, so now they said, well, you got to take that up in front of the other judge. And I said, okay. And then we got into it, and there was some stuff going on at the time. We passed on that. But in the file is the motion, the notice of the hearing, the motion to modify bond. It's pretty much consistent with her testimony, and the letter. Do you have the letter? It was addressed to you personally.
I don't recall if I do.
You got a copy of it? It's in the file. That was from Tad. I got Todd.
But he has been indicted prior to this.
Yeah.
For a select call, press 0.
We got some more tapes coming. All right, I'm ready to cross. What's this call? April 1st? All right, that was in the official court file. Again, Ms. Martis has been consistent throughout this, Judge, and I would just ask that you consider that. If we have to modify it, we'll modify it. But there's no fear in the state's motion. There's dangerousness, and I think that's what we're going with, and intimidation. Thank you.
Thank you. We have a motion practice in this circuit, so if there had been a need to modify the bond, I think it would have been brought before this court. It was not, however. So we're stuck with the bond that was issued by this court and adopted by the circuit court. And it's clearly in there. The defendant shall have no contact with the victim in this case. Words matter, and they mean something in this case. The victim, Kimberly Overstreet Martis, she may have gone to seek the defendant, but still the order is abundantly clear that there's supposed to be no contact, either directly or indirectly. And in addition to the rumors that have been going through the community, these two have been seen together. We had a law enforcement officer testify today that he had in fact seen them there. This was not in a business setting. It wasn't an office. It was out to dinner, like nothing had ever happened. This defendant is the master manipulator, and he knows how to appeal to the victim in this case. as do many defendants in these domestic cases. Therefore, the state would ask not to modify the bond, but to revoke it based
That's me.
based on what has been presented to the court today. And in addition to the motion that has been filed, the state would make a Roy Tennis motion based on the evidence from the jail calls that the defendant continues to have contact with the victim, even when he was in custody for having contact. He uses the jail call system to reach out to the daughter, and then I was trying to write down when I first heard these calls this morning, tell mom this, tell mom that, mom brings medicine, mom is Kim Martis, she's the victim in this case, and she was actually on the third phone call, she was present, and he tells her to work on her speech for Monday. And based on that, the state would ask the court to revoke the defendant's bond. Thank you.
I know this is your standing up, Ms. Clee, and that's fine. This is all backwards. I would normally let her go first, then you, then have rebuttal, but you went first, now her. Do you have something else in rebuttal?
No, I don't think so, Judge. I mean, again, the phone call to the jail add nothing to this hearing. I mean, and the situation, you heard Ms. Morrison, she's been the one doing it. She may have even made contact prior to this time. I don't know, but like I'm saying is, it's not him flagrantly violating your order. He knows Kim needs help. I mean, I'm sitting in the jail parking lot on Saturday. I don't like working on Saturdays. I golf. She wanted to bring the pills. I said, you can't take them in there. Can I go see them? No! I mean, then I get to stay there. So, I mean, Judge, it's not the situation that you normally have where you're trying to protect somebody. I think that there's conditions to ensure safety of her and the community and her testimony to be what it is. It's not going to change. Thank you, Judge.
All right, are we finally done?
Yes, Your Honor.
Okay, all right. So before the court is the state's motion to revoke bail in this case. I understand that we have an underlying domestic situation with a family. I know those are difficult on a good day, and I don't know if there are ever any good days in domestic situations, but I know this one is particularly difficult because we have two people in a long-term marriage with 4 children, so that does complicate a lot. We've got a lot of momentum going forward in that relationship. We've got a lot of things tied up emotionally and physically and monetarily in that relationship. So it is a difficult situation. The record of preliminary bond and hearing that I had in county court on October the 11th of 2022 that has been referenced several times, the operative portion here says there shall be no contact directly or indirectly, including but not limited to contact by phone, mail, electronic methods, or through a third party with the below listed. Neither person shall go within 100 yards of the other person's residence or person's place of employment except as allowed by youth or chancery court. And it lists Kimberly Overstreet Martis or 722 Inheritance Place, Flowood, Mississippi 39232. You know, for this bond, condition of bond to have any effect at all, the words have to mean things. And I know for the most part, the 3 conversations on the telephone were fairly innocuous for the most part. However, Ms. Lemon brings up a great point. In the third phone call, there was a portion where Mr. Martis told his daughter, have mom work on her speech to get me out. So I mean, that's one thing. But the motion itself relies upon a dinner that the officer testified to, and I believe Ms. Martis confirmed. So I don't believe that. I believe that happened. I believe it's probably happened more times than that. And whether there has been any difficulty or whether there's been any coercion or whether there's been any negotiation to drop charges or attempt to drop charges or attempt to influence the disposition of this case, you know, I don't know that, but the reason that the no contact order is provided is so that there will be a complete severance of contact between the defendant of the alleged acts and the purported victim of that act. And this is pretty clear. It says shall, and you know, I've had people, I jokingly say people would accuse me of only learning one or two things in law school, but if that's true, one of the things that I learned in law school was that words mean things. And shall is one of those words that means something. Shall means you don't have any option. It's not discretionary, it's mandatory. Shall means you shall, you will not. No contact is in a bigger font, underlined in this thing, directly or indirectly, and I'm not going to read this all again, but I think the evidence is clear that there was direct contact between the defendant and Kimberly Overstreet Martis at dinner, as outlined in the affidavit. I believe the testimony of Ms. Martis would indicate that there were probably other times of contact between the parties, but even if there weren't, the one was enough because there shall be no contact, and that was direct. Now, as to the significance of the phone calls, to me, and this goes to Mr. Coletti's argument that Mississippi Rules of Criminal Procedure 8.6 allows me to craft a remedy that still meets the goal of protecting the victim and the integrity of the system. And I would agree, I do have that latitude, but the phone calls cause me concern in that at the time the phone calls were made, he had already been arrested for having contact with his wife. So he's sitting in jail on Thursday, March the 30th of 2023 after having been arrested for violating a condition of the bond in that he inappropriately had contact with Ms. Martis, and even then he has 3 phone calls where, while innocuous by content for the most part, they still are messages to mom, whether it's for clothes, whether it's for medicine. But the third one was, you know, get mom to work on her speech to get me out of here. I mean, that's pretty clear. And to me, that indicates I don't know what set of conditions I can craft that keeps the parties apart. I think that contrary to the allegation that my no contact order has worked effectively to divorce the clients, I would say that's Mr. Martis that's worked to divorce the clients based on his actions. And I feel that all of this was in his control. All of this, I don't find Ms. Martis at fault for this. I understand her issue, and I understand her wanting to reconcile this marriage. I get that. But I do find fault with Mr. Martis. It was his job, not hers, his job to have no contact directly or indirectly. And that just didn't happen. So as it relates to the motion by the state, I'm going to grant that motion to revoke bail. As to bail going forward, you know, these 3 phone calls caused me great consternation because I just don't know how I can do that to keep him from contacting her. And I think that's got to be, and I get it's difficult, I get it, I understand that. But we got to run the criminal system to its end, whether that's a jury trial, whether that's an agreement, whether that's a dismissal of the charge, whatever it is. We've got to run that down to its logical conclusion, and we've got to have some purity in the system, and I've got to maintain my no contact. I can't afford to pick up the paper one day and read that you know, Mr. Martis has killed Ms. Martis in a fit of rage. I just can't do that. I mean, that one incident was bad enough, and she's fortunate to a great degree that she wasn't killed that night. So I don't feel like there are any conditions under 8.6 that I can craft, and I think that's all based on Mr. Martis' 3 phone calls that he made, even though he knew he had been arrested for having contact with the victim in this case, contrary to the conditions of the bond. All right, Ms. Lemon, if you will draft an order to that effect and circulate it to Mr. Coletti.
Your Honor, I understand the ruling, but I just want the record to reflect. That's the exact reason I can't be prepared to defend something I didn't hear until it came out of the witness stand. Had they provided those phone calls, Mrs. Martis and or Madeline could have explained that he wasn't trying to swear testimony. But that's the exact problem I have continually with this office is, oh, by the way, here's Connor's affidavit But the phone calls we got this morning, we're not gonna give that to you until you testify. That is denial of his rights to have adequate counsel at these hearings.
And I understand that, and you're certainly welcome to file a motion for Judge Ratcliffe to reconsider this.
Thank you, Judge.
He was an eminently fair man. All right, anything else?
Okay.
All right, that'll be all for today. Thank you.
I ain't gonna give you much more than that, you haven't been listening to you long enough.
You old man, you run by the old order and ugly. Yes.
He may protect me, you know.
So anyway, blood me out, and it sucks me
I just couldn't get to it. That's the problem.
Yes.